I also represent an All India organization of Ayvanna Temples, which is writ petition 39642. I am also representing the Shirur Mutt in this matter, which is IN number 18313 of 2020. I also represent the Thanthri of the Padmanabha Swami Temple, who has a direct say with respect to the practice of the Sabarimala Temple, and that is 18326, and the Chilkur Balaji Temple 11778 of 2020.
That you have mentioned almost in para one of your opening.
I have. The other three IAs I have not mentioned with respect to Shirur Mutt, therefore I'm pointing this out. Fair disclosure, these three IAs for intervention were dismissed by the previous bench on 10th of February 2020, but my submissions will be common. Millards, I will primarily focus on the relationship between 25 and 26, that vexed question. I'd only request my lords to kindly come to page number 251, para 6 of my written submission, in terms of the questions that I wish to canvass.
251?
251 printed, para number 6.
Yes.
My lords has it, my lady has it, please. My Lord Justice Bakshi has it, please. It is humbly submitted that in order to address the above questions, which is the questions framed for reference, and additional questions, a holistic understanding of part 3 is called for, of which articles 25 and 26 form part. Since part 3 of the Constitution deals with fundamental rights, the following foundational questions must be asked. I'd only request my lords to kindly take a look at the questions. Who do these rights inhere in? Who are they available against or in relation to? What is the nature of rights? What are their limits? And who enforces these rights? One question that my lady had actually asked, which I think is central to the question of relationship between 25 and 26. If 26 is about denomination, under which provision do non-denominational institutions trace their rights? That was the central question that is asked. In my humble view, all of this turns on the history of Articles 25 and 26. And what I've done for my lord's consumption is, my lords would find this spiral folder on everybody's bench. If my lords could kindly take a look at this. This contains the history of 25 and 26 in its entirety. And that will also explain the relationship between 25.2 and 25.1. I'd only request my lords to kindly take a look at this document, because this, in my humble submission, will be the nub of the matter, the core issue here. Because that seems to be the question that has been repetitively coming from the bench. So I request my lords to kindly mark paragraphs 1 until 30, rather 32. That is, the first 22 pages of this note are only extracts of the entire history of Articles 25 and 26, including the transition of the language as to how it emerged. I request my lords to kindly bear with me as I walk my lords through this history, because this should answer more or less most of the questions put in relation to the following questions. What is the relationship between 25.2 and 26? Question number 1. What is the meaning of a denominational institution? And is religious denomination different from a religious institution? What is the distinction? I want to show all of that. My lords may kindly have page number 2 of this spiral folder. I'll only focus on this and nothing else for now. My Lord Justice Amanullah has this, please. So, my lords, just kindly give me some leeway to walk my lords through this, because this should answer everything. Prior to the adoption of the Objectives Resolution on 22nd of January 1947, there were 2 preliminary notes on fundamental rights which shed light on the predecessors to Articles 25 and 26. One is Mr. B. N. Rao's note, who was the constitutional advisor, who broadly enumerates the kind of fundamental rights. Kindly see the first prototype of Article 25 under Mr. K.T. Shah's note, which is extracted in para 3. My lord sees that. So in the draft clauses presented by Mr. K.T. Shah in his preliminary note of 23rd of December 1946, clause 15 reads as under: every person living in the Union of India and is hereby guaranteed the right to freedom of conscience, which includes freedom of belief, worship, or profession of any religion, faith, or doctrine, as well as the negation of such belief, subject to public morality and order, subject to such laws as ensure the maintenance of public peace, tranquility, and good relations amongst the various sects and communities in the country. After the adoption of the Objectives Resolution, my lords, 5 subcommittees are appointed which deal with fundamental rights. Now kindly come to the next page, which shows who are the committee members with respect to the Fundamental Rights Committee. That is on the next page. I would request my lords to kindly read para 5, because this will show that 25(2) as it exists was always meant to be a proviso to 25(1). That is, it was never intended to affect 26 whatsoever, is an argument that has been made through interpretational route. I'm showing that historically this has been the case, which is, I'm leaving the consequences for my lords to judge. I'm only saying history of these provisions shows that 25(2) was meant as a limitation only on 25(1), because which is why it speaks of nothing in this article, and there's a reason for it. Kindly come to para number 5 at page number 3. All citizens are equally entitled to freedom of conscience and to the right freely to profess and practice religion in a manner compatible with public order, morality, or health. Please see what it says next. Provided that the economic, financial, or political activities associated with religious worship shall not be deemed to be included in the right to profess or practice religion. Therefore, it was meant to be a proviso. Kindly note, in my humble submission, the better part of these provisions and their amendments came from Kulapati K.M. Munshi, who can rightly take credit for crafting the language the way it is. So this is the proviso. Now, I request my lords to kindly take a look at the proviso for a moment. In the second line of the proviso, it says religious worship. My lord sees that.
Yes.
That subsequently becomes religious practice, because they decided that worship was too narrow and this should cover practice as well. And that was the discussion this was not even in the Constituent Assembly. This was in the committees before it went to the Assembly. Now, my lords may come to the next page. Para number 6 is Mr. Harnam Singh's draft. And my lords would see clauses 5 and 7 are the clauses introduced by him, which are more or less similar to the original draft. Now, I would request my lords to kindly come to para 7 at page number 4. And I request my lords to kindly make a note of these points for one good reason. Courts have been grappling since 1954 on the question of how do we interpret denomination. And Shirur Math has given the impression that denomination is something exalted, which is distinct and unique. Dr. Ambedkar and K.M. Munshi were not of this view, because 26 was meant to be a specific application of 19(1)(c) in a religious context, which is freedom of association is provided in 19(1)(c), and the limitations on freedom of association are in 19(4). 26 was meant to be a freedom to religiously associate. So in that sense, 26 is a specific manifestation of 19(1)(c) in a religious context. And therefore, denomination was never used in the context of giving it a separate character altogether. And I'll show my lords. Please, I'm so sorry. My lords had a question.
No.
Please, minutes. And this will emanate from the clauses proposed by Dr. Ambedkar on 24th of March 1947, page 4, para 7. What I'm trying to do through this endeavor is to show we need not go down the path of interpretation and get caught in the question of what is a denomination, when those questions have already been answered by the history of the provision. I've gone through all the written submissions. In my humble view, this portion or this history was not there, and therefore I thought this could put the matter to bed. Now kindly see this. My lords would see 14, 15 onwards. Can I just read this for the court's benefit? These are the proposals under Dr. Ambedkar's note of 24th of March 1947. Under the heading Fundamental Rights of Citizens, I've given the relevant page numbers from the existing compilation of the court. The state shall guarantee to every Indian citizen liberty of conscience and the free exercise of his religion, including the right to profess, to preach, and to convert within limits compatible with public order and morality. This is more or less Article 25. Now kindly see 18 onwards. Clause 18, 19, and 20 shed abundant light on the predecessor to Article 26. Persons following a religion shall be guaranteed freedom of association and shall have, if they so desire, the right to call upon the state to pass legislation in terms approved by them, making them into a body corporate. Can I request my lords to turn the leaf and kindly see clauses 19 and 20. Every religious association shall be free to regulate and administer its affairs within the limits of the laws applicable to all. Religious associations shall be entitled to levy on their members, contributions on their members. This is not relevant. 18 and 19 show that denomination was preceded by religious association, which is why in the debates, my lords would not find a specific discussion on what would amount to a denomination. Because a denomination is always meant to be understood as a collective expression of individual rights. Therefore, every body of people which comes together under a common belief to establish an institution will be entitled to rights under Article 26. So here's one question for my lords to consider. If 26 had not been there, what would have happened? It would have been still part of 25(1), except that they decided to pull it out of 25(1) and give it a separate character for one good reason. Because Part 3 can be applied to 25, but Part 3 cannot be applied to 26. And that is conspicuous in the absence of the language itself. Therefore, to ensure that collective rights or denominational rights or associational rights are not fettered by the limitations of 25(1), the bundle of rights within 25(1) were plugged out and carved out as Article 26. And there is a discussion to this effect. Therefore, the submission before my lords is, there is a very conscious reason for keeping 26 as a separate right as opposed to 25(1). There is a conscious reason for making rights under 25(1) subject to Part 3, but not 26. And the word denomination does not have a definition in the Constitution because it was always meant to be understood as a collective or an association.